Good morning and welcome to today's webinar, Understanding Estate and Trust Administration, the Postmortem Process for Estate and Trust Administration Explained, presented by Steve Elville, our Managing Principal and Lead Attorney here at Elville and Associates. My name is Jeff Stauffer, Community Relations Director at Elville and Associates, and I'll be moderating today's presentation. So welcome to those that are new to our educational webinar series and also to those that are frequent attendees. We encourage your general questions today as always, so please note them in the questions panel on your screen and we'll pause periodically to address them. Your questions really add value and help others learn, so don't be shy in posing your questions at any time. You received the presentation slides along with 2 checklists that Steve will be referencing by email yesterday to take notes if you wish. And at this time, the materials are also available in the section marked handouts to download if you wish. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please take just a couple minutes to fill out this very brief survey to offer us your feedback about the presentation, and we read and value every comment that you have to share with us. Here at Elville & Associates, we want to be a resource to you for your families and your planning needs. If you have an administration need to address, old documents that may need to be reviewed, or other planning needs to address, consider a consultation with Steve after today's presentation and use today's education as a jumping off point to get your planning started. Consultations, they're a great way to get your specific questions answered, have Steve understand your situation and help create solutions and a path forward for you. So I'd like to give Steve and the firm a proper introduction to get started, and then we'll jump right into the presentation. So Elville & Associates, we were founded in 2010 here in Columbia by Steve Elville. We have several different practice areas that we focus on here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 locations, and Steve and I are coming to you live from the Columbia Gateway Community location in East Columbia today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, client education, and superior legal technical knowledge. And we do focus on education a lot here at Elville & Associates in several ways, through our planning processes with our clients, also through over 100 educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program, or CCP as we call it here. We're one of only 2 firms in Maryland to have an accredited client care program through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. Just a bit about Steve. His work as an attorney for the past 20 plus years, I think 23 to be exact, has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, he works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, each year presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events. Steve was also named to the Maryland Super Lawyers list for an 8th time in 2023 and a 7th consecutive year, so congratulations to Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. And I've been privileged to be the executive director of since its inception. So if you'd like to learn more about how we work to make a musical difference in the lives of children each day, please feel free to reach out to me, and I would love to share our many stories of success with you about that. But for now, we're going to talk about understanding estate and trust administration, something that I have a little bit of experience in, having just gone through the process for a relative as a personal representative. And so we're going to do a brief poll just to learn what your experience has been in estate and trust administration. And the options, as I go ahead and launch this poll for a minute, are, what has your experience been with estate and trust administration to date? And the choices are, I have been the executor of an estate in the past on my own. Second, as an executor, I sought professional guidance throughout. That's what I did. I'm not sure what I would have done if I didn't. Third, I may be asked to be an executor of an estate in the future. Fourth, I want to keep my planning in order to keep costs down. And lastly, I'm an advisor here to learn to better serve my clients. So make the choice that best suits your situation and learn what's brought you here today for this all-important topic. We'll take another few seconds here. Okay, so we have 4% saying, I have been the executor of an estate in the past on my own. 17% say, as an executor, I sought professional guidance throughout. 21% say, I may be asked to be executor of an estate in the future. 36% say, I want to keep my planning in order to keep costs down. And 24% say, I'm an advisor here to learn to better serve my clients. So a varied group, Steve, for you. Welcome, everybody. Steve, I'll go ahead and
thank you, Jeff.
Make you the presenter
like that
here.
Number keeps going up. You said 23 years, Jeff. I thought it was just 20 the other day, and now it's 23. So what's happening here? All right. Thank you for that wonderful introduction, Jeff. And I've got my screen up, and I'm going to get my slideshow started. And if you'll bear with me just for a moment. Good morning, everyone. And again, I want to thank you, as Jeff did, for being here and spending your valuable time on a Tuesday morning, a beautiful June Tuesday morning. I think June is the best time of year. I've always said that, and some of you know what I'm talking about. So wherever you are today, whatever you're doing, we welcome you. I want to say just a couple of words about my staff and attorneys. Without them, I couldn't do what I do. Without Jeff Stauffer, I couldn't do what I do. And I thank Jeff. Jeff's getting ready to go on a well-deserved vacation. So congratulations on that, Jeff. I hope you have a wonderful time. And Jeff is not only our community relations director, but he is the executive director of our charity. And we thank Jeff for everything that he does. But we could not do this series without you. And for that, again, I thank you. And we want to make sure we're of a value to you today. So you're here for various reasons, and you know why you're here, and thank you for sharing some of that in the survey. I want to make sure that when you leave this webinar today, you've walked away with something of substance. And of course, the presentation itself is substantive. And whatever your needs are, whatever your interests are in this topic, I'm going to lay the groundwork for you so that you have a framework from which to operate. We're here to answer questions today. This is informal, and I want you to feel relaxed. If you are sitting near a tablet or a computer or a pad of paper, I want you to make some notes. There might be something that strikes you as very interesting or very something poignant that you're going to focus on, and I want you to work to write that down. A lot of this information is sometimes shrouded in mystery. And what we want to do today is unveil that, bring it to the forefront so that you can see that this is just like a lot of things in the estate planning area or the estate administration area. It's process driven. So if you can take away today the concept that this is a process, and it is not a hill to climb, that's not something that you can't do, but it is a little bit of a hill to climb. It's not a mountain, but it's a hill. And if we understand that through process, we can climb this hill and get to where we need to be, then I think you are where you need to be with regard to your understanding as of today. Now, with that said, everything I'm going to talk about today is something that mastery of this material would take potentially years. But that doesn't mean that you have to study this for years to be able to be successful in climbing that hill. So just give yourself permission to absorb this material, but to not have to become an expert in it. I'm trying to give you the lay of the land. I'm trying to give you some practical tools, and I think that will be a win today if you walk away thinking that and feeling that. Now, as we start the slideshow, of course, this cannot be construed as legal advice because we are not meeting in person in an attorney-client relationship or in a consultation, but I will do the best that I can to answer questions at a high level to try to point you in the right direction. But this is obviously for educational purposes only. Now, one of the things that I added to this presentation today is this first bullet point, which may seem very sensible and intuitive. What is estate and trust administration after all? Now, we're going to unravel the mystery of it and what happens after the death of someone. We're going to try to minimize confusion, and we're going to try to talk about the legal step-by-step processes and other step-by-step processes that are sometimes not necessarily 100% legal. But let's talk about what estate and trust administration actually is. Well, I was thinking about this, and not only is it a process, and that's one of the major things I want you to take away from today. And we're going to talk about those worksheets that Jeff has provided, those checklists. But I'm going to liken this to a life cycle. So we all are born, we live our lives, and we die, obviously. And some of us live longer than others. Some of us are healthier than others. Then I want to kind of analogize that to maybe something that we see on a very frequent basis in our lives, something like a play or a movie. And most of those plays or movies are kind of built on what we call the 3-act structure. Now, not all films and plays are built on the 3-act structure, but the beginning, the middle, and the end, right? So I was thinking about the life cycle, our lives. I was also thinking about the plays and movies that we watch. Most of them are built on this 3-act structure, the beginning, middle, and end. And then I was thinking about estate planning, and I was thinking, you know, one of the things we teach here at Elville and Associates is this process of planning, the process of not only designing a document and the plan and time to think about that plan, time to build and design that plan, but then there's a middle, and that is the lifetime process of keeping that plan updated. So I was thinking a lot about that as I thought about today's presentation. So we've got, you know, kind of a life cycle of planning, the creation, and then the maintenance and upkeep of the plan during life, which is so important. And then the final act, or what I would say the administration of our estate at the time that we mature or pass away. And we might say this is kind of in the terms of a movie, this is kind of the denouement of the whole process. So I'm going to just liken this to a life cycle on a very broad scale. I'm going to liken this to the actual planning process on a broad scale. And remember that if we're planning properly, we're not just in a 2-step process of kind of getting some documents in place and then we hope for the best when we pass away. We're going to have a 3-step process, just like a three-act play, so to speak. We're going to create the plan, we're going to maintain the plan, and then the plan must be administered at its maturity. So that's really what we're talking about today, is that final part of that 3-act process, or the 3-structure process, or 3-step process, the process of administration. So with that said, let's launch right into the material, and this brief overview will set the stage for that. Continuing with the overview, we're just going to be talking about practical steps, the significant legal and tax issues, and also how the professionals on the call today, people who are advisors, CPAs, insurance professionals, or people who are serving in the roles of trustee, the fiduciary, or the personal representative, which is a fiduciary role. How can they best work together? All of these people in support of the person who has lost their loved one, or in supporting the family of someone who has passed away. All right, so it goes without saying that this is one of our biggest concerns, whether it is a client concern here at our firm, or for the financial advisors and other professionals on the call, this is one of your clients' greatest concerns, or it could be one of your family members' greatest concerns. I know as we go through the planning process with clients, some clients are focused on administration. How is this actually going to happen when I pass away? How much will it cost? Who is going to take care of it? What is that process going to look like? And obviously, this is one of the underlying concerns in life, that obviously we have a finite time to live in this world, and our affairs are going to have to be taken care of. And we're going to decide individually just to what extent our affairs are in order. Now, there are wills and there are trusts. Now, we're talking about this very straightforward concept, but I'm going to act as if you know nothing about this, which I'm sure you do. Wills are the very foundation of estate planning, and revocable trusts are an alternative to a will. So most of the time when we're talking about basic administration, we are talking about a will, a document that is subject to probate, excuse me, assets that are subject to probate, meaning they're going to go through a process. Or we're talking about assets that have been removed from probate because they've been funded into a revocable trust. Now, for those technicians that are here on this webinar this morning, it is true that there are more trusts than just a revocable trust. So there are irrevocable trusts of all kinds, and those trusts are going to avoid probate at the person's passing. So assets that are held in trust are not going to go through the probate process, but they still have to be administered. So one of the biggest concerns, if we come back now to basics, come back to the basics, wills or substitutes for wills, which is a revocable trust. What is the biggest question that people ask? Well, one of the biggest questions that is asked in trust administration is what happens when I pass away? I would say that given the vast majority of clients, the vast majority of the population in the US, probably the biggest question that is asked, other than how do I avoid probate, is what actually happens if I have a trust? What actually happens when I pass away? Well, there's going to be an administrative period. So one of the things I want to explain so that there'll be no confusion throughout the presentation is if we have a revocable living trust, remember that trust is nothing more than a substitute for a will. It can be amended, it can be changed throughout life. But at the person's death, the grantor's death, I'm going to say, here's the trust and here's the date of death. Upon that date of death, there is an administrative trust created, meaning that living trust, that revocable trust has now become irrevocable. That's one of the most basic but the most important concepts to remember if you are in a position to have to administer a trust. And that is, that trust becomes irrevocable at the grantor's death, and it has to be administered. So this concept of the administrative trust from the date of death until the time of distribution is something that I want you to have a good understanding of. And I call that period from the date of death until the time of distribution, I call that the transitionary period. So that's pretty understandable, I think, for most of us. But if you have questions, I want you to please let us know during this webinar. Jeff is a wonderful host, and he will know when to interrupt me. He will know when you have asked a question through the chat. So we want to understand wills, because the wills by their very nature are subject to probate. Trusts avoid probate if they're properly funded, and if they're irrevocable already, they avoid probate. But a living trust becomes irrevocable at the death of the grantor, and now there's a transitionary period, an administrative trust to administer prior to the final distribution. So that's a basic concept that we want to be aware of. Now, before I move on, you have been given two checklists. One is for probate administration and another one is for a trust administration. You're going to notice that these checklists are somewhat similar, but different. So don't be confused when you look at those. What is my big message to you today? Be driven by a process. And you're going to hear me say this, not only on this slide right here, but in others. So I'll be, with your permission, intentionally redundant. All right, so how do we unravel this mystery as we continue to think through someone has passed away? Okay. We talked about understanding the difference between wills and trusts. We talked about understanding the transitionary period. But now, who will be there for a surviving spouse or children? Okay. What do they do, or what do you do? I was just speaking with someone this morning, and similarly, I was speaking to another person yesterday, completely different situation. The question really is, should I move forward with the administration? In other words, what do I do? Be aware of. Fiduciaries do not have to serve. They do have a choice, but of course, most people are going to serve. But the question they ask is, what do I do next? And that's why I'm saying here redundantly, we want to be driven by process and not circumstances. The circumstances at someone's death could be very straightforward, very predictable. That person was very organized, or their life circumstances were such that there was no big issue, or the circumstances could be completely out of control. Multiple rental properties, health issues that at the time of death, claims of creditors, all kinds of things could be going on. But it's through planning and education and organization that we can get ahead of that. Now, we can't always be ahead of it. And as personal representatives / executors or trustees, whatever that fiduciary role is, we must be prepared, and we can do that through education. Now, I'm going to give you some examples today. My purpose here is not to kind of drown in examples and minutia, but my case examples are really just to give you an idea of just how broad this area is. And, you know, after many years of seeing thousands of estates or trusts, just as if in your field, whatever that may be or may have been, you intuitively see things. I see these things, and good estate planning and estate administration attorneys do see these things. You're not going to be able to see everything because you will have blind spots, and that's okay. But through education and through counseling and through professional advice, you'll be able to get over those hurdles and blind spots. So I'm going to give you a few examples today. One example is where things are very clear. Another example will be where it's a typical couple and they are alive and one of them has died and they have certain assets. We want to be able to identify those. Then we're going to see where there's a survivor of that couple. And now the circumstances could be different and are different in my example. Then I'm going to show a very simple example where there's no planning at all. And there's a lot of things that are up in the air. Some of you I know on this call because you said so. Some of you have been executors and personal representatives before, and you've dealt with estates. So even if you haven't, however, you've seen relatives and you've seen friends of your children, and you've seen other types of individuals who come from maybe unfortunate circumstances where there was no planning. So I want you to just kind of understand that there's a very broad topic being discussed here, and all we're really doing today is getting our arms around it and trying to build a framework and a process. Now, in my first example, here we have a single person. We may come back to this, but I'm just going to go through these very briefly so we can get on to the broader material. Here's a person who is older. They were never married, a single person. They have one child. They have a house. They have some cash. They have an IRA. And look at this. They have savings bonds. Now, see, that's one of those red flags. Not a bad thing. It's just something that we need to be aware of. What do we know about savings bonds? Well, those are taxable. Those are what we call income in respect of a decedent, IRD. Someone's going to have to pay the tax, okay? So that's a red flag there. We know someone's going to pay the tax on the IRA when it's distributed. So we kind of have the lay of the land here. In my pattern here, this gentleman had never made any lifetime gifts and he has no creditors. He had Social Security at his death, and he's got a will. If you look at this last bullet point, he's left everything to his son. He has one child. Everything's very straightforward. He's left everything outright. So this is a very straightforward situation. We have probate on the house because that house was in his own name in my example. probate on the cash, and we have probate on the savings bonds. That's one thing I kind of want you to pick up on here. Do we have probate on the IRAs? And the answer is no, because in my example here, this person had a beneficiary designation, which was his son, Charles. Now, for those of you who are really knowledgeable, I'll just say Charles is healthy and well. So when he received this IRA, how many years does he have to take that IRA out? Well, to pay all the tax on it. Well, we know it's 10 years now under the Secure Act. So Charles is not exempt. There's no reason to believe he's exempt under these facts. So that's my example number one, prototypical will situation for a single person. Just to show you that have never been on this webinar, the difference in fact patterns. Now I'm going to switch completely. Let's go down to the bottom bullet point. It says the estate plan here is in place. This is a married couple in their 60s. And there is a revocable trust. There is a substitute for a will. And look at this, reading left to right. It says the husband here, Jack, who has passed away at 69, he has left everything outright to Janet, the survivor. So here's a couple. They were successful in life. They were happy. They have 3 children. These children are healthy and well. There's nothing to indicate otherwise. And they have a residence, and there's no mortgage. They have cash. They have retirement plans, IRAs, 401ks. They have a joint bank account. They have a joint brokerage account, okay? They have life insurance. So this couple kept their life insurance, and look, they have a fairly significant cash death benefit here in their life insurance. And then they were so successful and they wanted to have a second home. So they have a second home over on the Delaware shore here in Maryland. That's a common thing we see quite a bit. No mortgage on that as well. So here we have a very happy couple. Unfortunately, one has died. They have revocable trusts that leave everything to the survivor. Very straightforward. They have never made lifetime gifts. They have no creditors. And the survivor now, the spouse, Janet, is going to go on with her life. So here's a situation where we don't have someone single that has passed away. We have someone married. And now this administration should be rather straightforward. We have a revocable trust that leaves everything to the survivor. What is a disclaimer? Well, a disclaimer is a tool for moving assets from one person to another. So here, Janet would not need a disclaimer, probably for any reason. But why wouldn't she need to move assets? Well, she wouldn't need to move assets for any reason that we're aware of. She doesn't need to disclaim assets to anyone. And she doesn't need to disclaim assets for estate tax purposes. So the estate tax exemptions right now are how much? Well, those of you in the know on this webinar know that the federal exemption is $12,920,000 each. So each of these spouses has a federal estate tax exemption of over $12 million. The Maryland exemption, because these folks in my scenario are a Maryland couple, is $5 million per person. And Janet, the survivor, has the ability to use portability to port Jack's exemption amount over to herself. So she does not need a disclaimer, which we don't have time to go into. What if this trust had a formula clause? Now, a formula clause is something that's beyond the scope of today's discussion, but it has to do with the way the revocable trust or trusts were structured as far as the disposition between spouses. So for today's purposes, I just want you to know that when you see something like this, when you're dealing with a married couple, the disposition between the spouses upon the death of one of them could be very simple, or it could be more complex, such as the use of a formula clause. In my opinion, there would be no reason to use a formula clause here because this couple can leave everything to the survivor, to the marital share, and they have an umbrella of almost $26 million of exemption. And even though I have not added up these assets here, it's pretty clear that this couple does not have anywhere near $26 million of exemption. So this is a situation where we have a married couple and a revocable trust. This next fact pattern is simply a continuation. And here we're just going to spend a few minutes. Janet is the survivor, but this is 20 years later. Now, situations can change, correct? So now, if you are administering or helping Janet to administer this trust 20 years later, is her life different? Almost certainly yes. Look at this. We still have the 3 children living, but one of them has been injured. There has been a trauma. There's been a car accident, and this person has a brain injury. Do these things happen? Yes, they happen all the time, and that's why I'm being very realistic in this example. But now look at this. Janet is no longer living in the house. She no longer has the Delaware house. She's living in a continuing care retirement community. She's put her $350,000 into a deposit. Now she still has a revocable trust in my example. As we look down to the bottom, that revocable trust still leaves everything to the children equally. And look, now she's the single person. She doesn't have a surviving spouse to worry about how the disposition is going to go to a spouse. She's leaving assets in further trust for those children. Why would she do that? Well, you see that as a fiduciary and you say, well, that's to protect the children from the claims of creditors or from themselves or for some other purpose. So she's leaving assets in further trust. So we have cash, we have the deposit at the CCRC, we have a rather large IRA that has to be distributed. We have a brokerage account. Look at how that's grown over the 20 years. Janet still has her insurance. So there it is. And now she's decided over those years, she decided she liked the sunny shores of Florida better than Delaware because it gets a little cold over there in Delaware in the winter. But she said, I'm tired of that. So she has a house in Florida. Janet still hadn't made any gifts during life, but look at this. She's done some crazy things, and this does happen from time to time. This could be that she was doing too much shopping. She was doing too much shopping on the home shopping channel. There are elderly people who actually get abused. She might have been the victim of some kind of scam. There could have been someone take advantage of her and run up credit cards. There could have been all kinds of things that happened. So that's unfortunate. She has a bunch of creditors. So now what happens when she dies? So you as the fiduciary or you as the advisor for the fiduciary, you take all this into consideration in your approach and you say, what are the things that really stick out here? Well, there's a traumatic brain injury. So when that brain injured person, that brain injured child gets their share, is it important that that share go into a special needs trust instead of a general needs trust? That could be something that could cause the fiduciary to say, you know, I need to do something above and beyond the normal administration because I've got a situation here. I believe that's your fiduciary duty. That deposit at the CCRC, we want to know when that's coming back. We want to know how much of it is coming back. The IRA, when you're making a claim on that IRA, when you're helping the beneficiaries make the claims on those IRAs. Well, here, let's make the assumption that those IRA shares are going into further trust because that's what it appears to be the intention here of the planning. And if one of the children is going to have a special needs trust, we need to recognize that that person's share of the IRA would be exempt under the Secure Act. So meaning that person would not have accelerated 10-year taxation on that IRA share. Florida residents, we have property in another state, so we want to make sure that property was in the revocable trust as well. So these are the kind of things that I'm flagging here just from this fact pattern. The idea here is to try to get you to start looking at this as you start to get your mind, your arms around a particular fact situation that you're dealing with at the time of someone's death. And our last fact pattern, although there could be hundreds, is a person who died without a will. This person had 2 children. He was separated but not divorced, not uncommon. And His spouse lives in another state under unusual circumstances. One of the children has had difficulties. Well, here, this person had a typical scenario of a checking account in his own name. He had an inherited IRA that he had received years ago, prior to the Secure Act. So this person is not subject to the 10 years. This person received an inherited IRA back in 2012, let's say. And that IRA is being stretched out based on that person's life expectancy because they weren't subject to the new rules. He has a car to dispose of. He has life insurance, but there's no beneficiary. Savings bonds. He's made prior gifts. This person impoverished himself. So that's an unusual fact pattern. He at one time had higher assets, but he gave them away. So what do we have here? We have probate, but we have intestate probate. This person died without a will, so someone has to be appointed as the personal representative or executor. They have to take charge of the assets with the letter of administration. Some states call this the letter of testamentary. They have to dispose of and take charge of the checking account, sell the automobile. They have to make a death claim on the life insurance. What do we know when we see the life insurance has no beneficiary? That tells us that this non-probate asset is actually going to become part of probate. The savings bonds, we talked about this before. The savings bonds are going to be part of probate. They have to be cashed out. The taxes have to be paid. Lifetime gifts. Is there any kind of ramification for that? Well, no, because we know that this person had a $12,900,000, $920,000, I should say, exemption from gift tax. So this $500,000 gift that this person made is not going to be subject to any kind of gift tax because he did not exceed the limit of gifting. And does Maryland have gift tax? And the answer is no. Maryland, like most states, except for two, I believe, Maryland has no gift tax. So his $500,000 gift has no ramifications. Now, we're dealing with an intestate estate. Do we still have all the normal processes? Most of the normal processes are still in place, except this is not driven by a will. So how does someone get appointed as the personal representative? Well, one of the children is going to have to step forward, probably the child that's not in bankruptcy, and petition to open the estate. Could the spouse petition? And the answer is yes, but it looks like she's not going to probably do that in this fact pattern. So we might have to get the consent or the permission of that person. So these four examples, I hope to just kind of set the stage for just four examples of hundreds of potential factual scenarios that you could encounter. And I hope there's some value to you in me having going through those examples. Jeff,
Steve, will now be a good time to.
Thank you, Jeff.
Okay,
yes.
We're reading each other's minds here. I have a few questions to pose to you, please. First question is, what happens when one member of a joint revocable trust passes?
Thank you for that wonderful question. A joint revocable trust could be drafted in all kinds of different ways. And joint revocable trusts have their origins usually in the community property states out west. They are popular now in separate property states such as Maryland. And it's going to be a question of, when we say what happens, it's going to be a question of what is the disposition between the two spouses. Just a few examples. Is the disposition kind of an outright distribution? One spouse dies, the contributive share, that's a legal term, the contributive share of that deceased spouse, is that 50%? Many revocable trusts are for traditional couples that just say everything that's owned in this trust is 50-50. So if we say that the contributive share of this particular spouse under this particular situation is 50%, then that 50% is going to pass to the survivor either outright or in what I would call a survivor's trust, which is a trust that is basically just a continuing revocable trust for the survivor, where the survivor has a general power over those assets and can give it to whoever he or she wants. Or you may choose as spouses to leave assets to a marital trust. I call this kind of a structure that protects from the influences of a new spouse, but also provides for asset protection for the survivor. We'll call that a marital trust versus a non-marital trust, meaning a trust that is not going to qualify for something called the marital deduction. So what happens to that deceased spouse's share is going to depend on what the trust itself says about the disposition between spouses.
Okay, thank you. Next question is, what states have gift tax?
Thank you for asking that. I think Jeff and I will research that. I want to say Connecticut, or I want to say Connecticut has gift tax. I could be wrong about that. And I believe there's at least one other state. So if you'll be patient, I think Jeff and I will research that and get back to you.
Yes, we can find that out. Next question, a little specific, but let's see if you have any general thoughts. So scenario, there is a revocable trust in place, husband and wife, no children, one passes away. The trust and will went to the courthouse. The papers to sign came back. What do these papers mean, signed and returned by the sole survivor trust owner?
Well, I'm so sorry that based on those facts, I wouldn't be able to help here without further information. But it does seem unusual that there's a revocable trust and everything kind of ends up at the court. Now, what you may be saying is that this revocable trust was not funded. So remember that a revocable trust has two steps. We have to create the trust, and then we have to make sure that the person's assets are titled in the trust, meaning the non-retirement, non-IRAs, those kinds of assets, cash, real estate, are titled in the trust. And it sounds like maybe this particular trust might not have been funded, and the estate of the person had to be opened, let's say at the Register of Wills or the courthouse, and now that estate would maybe come back to the trust. We call that a pour over, back to the trust. So that's one possibility of what you're saying. Another possibility is in this modern era, it is possible to do elder care planning, where we are planning with a revocable trust, and this is way beyond today's discussion, but at the person's death, that is disabled, the non-disabled spouse, that an estate can actually be forced to be open on purpose because we're trying to do certain kinds of elder care planning. But I would think probably it's because this trust wasn't funded, and there's a lot of confusion maybe about why it's going to the court. But we're happy to speak with you at another time about that.
Okay, thank you, Steve. Those are all the questions for now.
Thank you, Jeff. So knowing what some of the examples are, knowing that process is a key, we want to have empathy, obviously, for the client's situation, if it's a client, for our professionals on this webinar, or for the family member or friend. This is key. This is intuitive and something, obviously, we don't have to spend a lot of time, but this is an important thing that is not to be overlooked. I dealt with a family situation recently where the lack of empathy was shocking. And I think, this is something that we always need to keep in mind. What kind of family support does this person need? If you are a professional on this webinar, I think your whole firm, in essence, should be considered a resource to the survivor or survivors. We want to be creative and be able to provide resources to people. Sometimes professional advisors have lists of resources. Sometimes those are still in process. And sometimes very well-informed fiduciaries, such as some of you on this webinar, are very informed about resources. But we want to be able to act as a counselor and coordinator. It's not all about technical issues. There's a lot of technical issues, but some of this is very personal and not all technical. The client or the person who is the survivor needs to take care of themselves first. There's no hurry. Now, with that said, I'm going to say most of the time there's no hurry. Of course, there are certain benchmarks. There are certain tax deadlines. Most of those tax deadlines are something that can be dealt with at a later time in the early going of a crisis. But we want to make sure that if there does need to be something addressed quickly, such as those 14 rental properties, or there's an emergency, or someone has broken into the residence and they're trying to get the tangible personal property right after someone dies. We need to make sure that all locks are changed. We want to make sure that if there is something to be concerned about, that we're making sure we're available, but most of the time there is no hurry and the person at issue can take care of themselves. All of the advisors or fiduciaries should be working together. Now, this has to do with not just deciding to do this at the time of someone's death. This has to do with good planning, and I'm kind of extrapolating here a little bit, but when you think about it, good planning during lifetime, remember that three-step lifetime process: creation of the plan, maintenance and updating of the plan. Well, in that maintenance and updating of the plan, there should be lots of communication among the advisors, not just at the time of someone's death. How are these advisors really going to coordinate with a fiduciary if this is the first time they've spoken during the whole lifetime of the person who passed away? We want to assure the survivors that everything is in order, that funds are available, that final arrangements are being made, and that we are here to help. And that if there are family-related issues, which sometimes there are, family-related issues about battles that have happened within the family, misunderstandings, someone is being disinherited or receiving less than someone else, these issues have to be understood as being potentially problematic. Because remember, as we're going to see, that beneficiaries are entitled to notice, and we have to be prepared to deal with that. Expressions of sympathy go without saying, and of course, attending someone's memorial service can mean a lot to a family, and it's something that should be a professional standard of excellence. So let's look at our checklist now, and let's talk about this legal step-by-step process. And my purpose in the next 15 minutes or so is just to show you that these processes are similar. Probate is similar to non-probate. Most people think, well, if I've got a non-probate estate, there's nothing to do. And I would say there are some rare occasions where that is true. Let's say someone passes away, that they were a single person and they have a single beneficiary, usually a child. There's no one to account to. There's no one to have to jump through hoops for except that one surviving beneficiary. And let's say that person died with no creditors, their affairs were in order. Well, that's where a non-probate estate can be very powerful, and the administration of that estate can be very streamlined. But that's usually not the case. There's usually more than one beneficiary, not always, but usually. And so what I'm going to show you here is that these steps are necessary and recommended even on the non-probate side of things. Organization is key, using a checklist, and critical dates is key. So what is this legal process in probate? Now, remember, this is a very broad subject, very, very complex subject that I'm trying to pare down for you here in less than an hour and a half so that you have a framework. Well, the date of death, death certificates are eventually issued. Usually this is not a problem. Sometimes these death certificates are delayed. Sometimes the circumstances of death are not common. So we have to kind of wait for our death certificates, which usually are not a problem. We have to open the estate, get letters of administration. Now, summarizing a very complex process, an inventory and information report is due within a certain period of time. And this is telling the Register of Wills how much is actually in the estate. Now, this is in a regular estate, and we don't have time to go into all the nuances. The information report does what? It basically tells the Register of Wills, is there anyone that is being left property or has been left property prior to the decedent's death that is subject to what? Inheritance tax. Maryland is not only one of the states that has a state estate tax, but it has an inheritance tax. And that inheritance tax is collected by who? the Register of Wills. So this is what the Register of Wills is looking for. Now, claims against the estate, I'm going to hit the high points here. Claims against the estate have to be claimed within 6 months of the date of death. Date of death, okay? That means that creditors are a little bit behind the 8 ball from the beginning in Maryland. Now, there is a new spousal elective share law, which is beyond the scope of today's discussion. Just know that spouses now in Maryland have greater protections since the fall of 2020, and a surviving spouse that does not receive at least a certain amount will have the right to elect against that estate. And they will also have the right to elect against a trust. Disclaimers, meaning I received property, but I don't want it, or I'm getting ready to receive property, I should say, but I don't want it. I'm disclaiming that property. Those have to be made for federal purposes. They have to be made within 9 months. Federal and state estate tax returns have to be filed within a certain period of time. Extensions are allowed, but not an extension on the time to pay the tax. So the federal Form 706, the Maryland Form MET1, these have to be filed. These forms are going to be due if there is a couple of circumstances. The first one is maybe the assets are not great enough to actually require the filing of these returns. However, a surviving spouse wants to do what? They want to choose portability. They want to port the exemption, the unused estate tax exemption amount, or what is called the DSUE. The DSUE, the deceased spouse's unused exemption amount, is being ported to the surviving spouse. They have 5 years now to do that, as you're going to see on your checklist and in this presentation. That time has just recently been extended to 5 years. So Uncle Sam is giving you a lot of time. And Maryland, in this past legislative session, as of October of this year, is basically saying we are in coordination. We agree with the federal rules on this issue of portability. So estate tax returns are going to be filed if there's a need for portability, if there is a need to make the marital trust election called the Q-tip election, or if there is an actual taxable estate of more than the threshold amounts. I just mentioned the Q-tip election. It has to be made, and it's made on that Form 706. We talked about the portability election being 60 months now, not 24 months, and not 9 months, as used to be the case. So the government is giving us tons of time to do this. The first administration, the second administration account, and subsequent accounts have to be done within a certain period of time, unless there is some kind of expedited estate that is allowed by the Register of Wills. And when we get right down to it, what is happening here is the personal representative is doing what? Accounting from the date of death until the time of distribution. And when they do that, they are entitled to a release of liability, probably by court order. But we're going to see here on the trustee side of things, on the trust side, that a trustee is entitled to be released as well. Now, there are certain retirement plan timelines. Now, this is something that's troublesome to deal with, but it's something we need to understand. I just described, in a nutshell, the process of probate, the process of a regular probate estate over a 9-month period. But what we're talking about here in this next to last bullet point is retirement plans, IRAs. Those have to be claimed by somebody. Those have to be claimed by the beneficiary, usually. But that's not really part of the probate estate, because let's assume that our retirement plan accounts are properly beneficiary designated. So that's not part of probate. So what is the fiduciary to do? Well, in my opinion, their obligation is to help facilitate this and move it along. And there is a timeline for this. The timeline is, for those of you that are writing this down, September 30th of the year following death. Now that's a mouthful. September 30th of the year following death is the date at which beneficiaries are final. That's another subject for another day. It could be something that's important in your particular estate or trust that you're the fiduciary for. October 30th of the year following death is the date by which the trust document, if it's a trust, has to be given to the plan custodian. And December 31st of the year following death is the date that retirement plans have to be separated into separate inherited IRA shares, basically. So that's the timeline that you need to be aware of, that by the fall of the year following death, you need to be making sure that the beneficiaries, or if you as the fiduciary have to make those claims, that you're on top of that. And of course, we've talked a little bit about this in this presentation, but beyond the scope of today is the Secure Act and the Secure Act's effects on administration. When we are helping beneficiaries get those IRA shares into their names or into trusts that have been established for the beneficiaries, we need to be aware of the taxation element of how that's going to be looked at. And unless there is an exemption, unless one of these 5 types of individuals are exempt, meaning minor children, surviving spouses, chronically ill people, disabled individuals or their special needs trusts, or 5, a person who is less than 10 years younger. You've seen this and heard of this, but that in a nutshell is the 5 types of individuals who are exempt from the Secure Act, and anyone else is not exempt, meaning they have to take that retirement plan distribution. In a nutshell, they have to take that in 10 years. You need to have a working knowledge of that as a fiduciary. And of course, you can rely on professional advice. Now, there are tax returns that have to be filed. Those are called 1041s. Those are the estate and fiduciary income tax returns. Remember, I used the term federal estate tax return and Maryland estate tax return, but this is what I would call a fiduciary tax return, the 1041 and the 504. Uncle Sam wants to know, from the date of death until the time of distribution, how much income tax is owed from that trust or estate. So in other words, from the date of death until the time of distribution, the tax reporting has to be done through a tax ID number, an EIN. And Uncle Sam wants to know how much income there was. So that's what this does. And then as a fiduciary, you're going to want to receive a closing letter from IRS or Maryland about the various taxes that could be due in a state. Why would you want this closing letter? Why would you also want to be released from liability? For the very reasons of the last sentence there. You are, as a fiduciary, subject to liability, so you want to do your job, do it at a very high level, and also be released from liability. Now, if there's no questions, let's go into the non-probate side. And this one is going to be a little bit more expedited, because one of the things you're going to see here is that the non-probate administration. So going back to just setting the framework here, we've talked about probate, and probate is what? The proving of a will to be valid. The proving of a will to be valid. And one of my examples, I was giving you an example of someone, that first gentleman, who died with a will, and he actually had probate on the assets that are in his sole name with no beneficiary. Well, the last example I gave was a single person who had no will. Now, that person is going to have probate on those assets that were in his sole name, even though he was married. The first person was single, had probate assets. The second example, meaning the last example, the person was married, separated, but he still had assets in his sole name, but he had no will. In both cases, there's going to be probate. Now, this is non-probate. This is a person who has died, let's say, with a revocable living trust. That revocable living trust was properly funded. It was given or retitled assets into that trust. And now at that person's death, those assets are subject to no probate. They're non-probate. But notice, I'm recommending that we walk through the same steps. Now, why would I recommend that? Well, remember, you as a fiduciary, or the fiduciary, has what? Fiduciary responsibility. So if I'm a trustee of a trust, everything is in that trust. The deceased passes away. What can I do? Well, there's no probate. So I could distribute all of those assets immediately to all three of those children, let's say, three children. But would I do that? Well, probably not. If I were advising a person there, I would say, don't do that. Why? Because you have fiduciary duty. We want to account for everything at the date of death. We want to give notice to creditors. Okay, now I just threw some of you for a loop. I'm just talking about a revocable trust here, but I also said we could give notice to creditors. Well, since 2014, Maryland allows a fiduciary of a trust to give notice to creditors to do what? To foreclose the claims of creditors against a revocable trust. Now, I personally have never seen a revocable trust have a claim against it, but it is possible under the 2014 Maryland Trust Act for a creditor to make a claim against a trust. It has always been possible for a creditor to make a claim against a revocable trust. Remember, a revocable trust is being administered. It's in that transitionary period. So we are allowed to give a notice to creditors. It's in the code about how we do this. And we can give creditors notice and stop the time for them making a claim or cap the time that they can make a claim. Notice also that beneficiaries have to be provided with notice. Since 2014, trust beneficiaries are entitled to information and they are entitled to notice. These are the qualified beneficiaries, okay? So you as a fiduciary have this obligation. You could just distribute everything immediately, but you have reporting requirements. There could be spousal elections that have to be made if there's a person who died and now there's a surviving spouse, or there's a portability election to be made. There's all kinds of things that need to be done. So what would I suggest? I would suggest that you walk through a process even though there's going to be no probate, because you have fiduciary responsibility. And at the end of the day, we have the same basic issues that we are dealing with, the same accounting issues, the same fiduciary issues. And look at this next bullet point on the top of this page. A release, a waiver, and even a refunding agreement to say, you know, I am making distributions. I might even be satisfying some requests for distributions that you've asked me for, but I want to be indemnified, okay? I want to be released. I have provided what? A final accounting. I have been transparent. I have done my job. I have filed all tax returns, and I want to be released so that no one can sue me after I distribute the money. So the word to the wise is to treat a non-probate administration similar to a probate administration, except for the fact that the non-probate administration is not overseen by the Register of Wills. It's private, but I still think there's plenty of liability as a fiduciary that you have, and you want to be conservative and you want to be transparent. What are the practical steps? Hey, Jeff, let's have another question.
Couple questions, if okay with you?
Yes.
Okay, great. So we have one that was just emailed to me by client of ours. Could you please repeat the federal gift tax exemption and rate? And how would the government know gifts have been granted? Are these gifts given during a lifetime or at death?
Great question. Thank you, and hello to you. The exemption amount, it's a unified exemption, so the estate and gift tax exemption is $12,920,000. $12,920,000. And remember, Uncle Sam does not start counting this $12 million until you've exceeded the annual exclusion amount of $17,000 per person per year. So now Uncle Sam starts counting, and the latter part of your question is, how does Uncle Sam know? And how do they count? Well, they count because you have an obligation to file what is called a Form 709, which is a gift tax return. And that gift tax return memorializes your gift so that Uncle Sam knows how much above the $17,000 that you have used and therefore subtracting from your 12,920,000. And the last part of your middle part of your question was, what is the rate? The gift tax rate is 40%.
Okay. And next question, how do you add expensive cars to the trust?
Wonderful question. Well, I think that's going to be a practical question. So in the old days, we would always retitle cars, vehicles, in the name of a revocable trust. And then what you have to do when you do that is you have to make sure you notify your auto insurance company that the trust itself is the owner and the trust is an insured. So we have to make sure that you do that. Now, in the modern times, I'd say probably more than 5 to 8 years ago now, the DMV, the Department of Motor Vehicles, will allow you to make a vehicle transferable on death, TOD. So you no longer have to title a vehicle into a trust. You can make it TOD, if that makes sense, transferable on death to a person. So that's how we get cars, vehicles into a trust, and we have to make sure that we retitle them and we've notified the auto insurance company, or you keep the vehicle out of the trust, in my opinion, and you make it TOD, transferable on death. This assumes that the vehicle is not joint, because if it's jointly held, my understanding is you cannot make it TOD on the death of the survivor. You can only make it TOD if you are the sole owner of it. So it's just a step-by-step factual analysis.
Okay, and last question for now. Surprised on the information on savings bonds, and then he has the initials IRE given POD. Are savings bonds part of the probate given POD, or some savings bonds can pass to the survivor, changing owner with need to cash in, i.e. with POD on savings bonds do not need to cash in, so therefore no IRE.
Yes, thank you for that. IRD, I apologize, D as in dog, income in respect to a decedent. So I agree with you. Every answer to savings bond situations does require, you're exactly right, does require an analysis of who the beneficiaries are, how old the bonds are, and so forth. A TOD bond is not going to go through probate, so thank you for saying that. I was referring to a bond that is titled in a single person's name at the time of their death, or a survivor, a joint owner who is now a survivor, and those bonds are going to be in the estate of that person, and taxation has to be taken into account. And this is going to be an analysis of the CPA and attorney involved, because the taxation could be trifurcated, so to speak, or bifurcated between the last tax return of the decedent, the actual fiduciary estate, okay, or the tax bracket or taxation of the beneficiaries, the income of the beneficiary could be put on their tax return. So sometimes this is an analysis in larger amounts of savings bonds that maybe tax can be minimized if it is allocated in different ways other than just to the decedent's estate. Okay, Jeff.
Okay, very good, thank you.
Thank you. So as we start now, in the interest of time to start wrapping up, what are the practical steps that need to occur? So a surviving spouse or other survivor needs to probably meet with the fiduciary or become a fiduciary within no longer than 30 days. Coordinate with other advisors, organize, use checklists, as I've redundantly said throughout. I would argue that fiduciaries should have an inclusive process. Remember, excuse me, that Maryland law does say beneficiaries are entitled to information, not only just in probate estates, but in trust estates, so to speak. And I would just say that on a case-by-case basis, you will deal with very difficult beneficiaries, but as a whole, the process should be very transparent and inclusive. And I think that everyone will be happier, including yourself as the fiduciary, generally speaking. Now, do you have to tell the beneficiaries every single thing that's happening? The answer is no. But in my opinion, beneficiaries are entitled to basically all information in a trust administration, and they're entitled to a fair amount of information in an estate administration. So due diligence, Make sure that survivors are coping, that they have assets. Don't don't guard assets. Make them available, generally speaking. Make sure you're methodical. Make sure that the surviving spouse, that he or she is thinking about their own planning, not too soon, but certainly within a reasonable period of time, that they want to address this process, which is very painful after the death of a first spouse to die. Again, organization during life is very strongly recommended. General readiness, document storage, making sure that documents are stored properly, that fiduciaries are educated. All of this involves the practical steps. Now, what are the most significant legal and tax issues that advisors should be aware of, or you as, let's say, a layperson who is going to rely on advisors? Well, we want to review the titling of assets prior to death. We want to say, well, if we're using a will-based plan, well, we must be doing it intentionally. So let's make sure that our beneficiary designations are absolutely correct. Verify and re-verify those beneficiary designations, especially after the Secure Act and especially after COVID. We want to make sure we value all assets after death and we understand valuation. We want to caution the receipt of assets by a surviving spouse. Now, my experience is that surviving spouses many times naturally, but not necessarily correctly, will retitle assets almost immediately after the death of a first spouse to die. This is not a generally good idea. The first spouse to die might have had specific things in their will or trust that dictate how the assets go to the surviving spouse. The surviving spouse could accept assets too soon and should have not accepted those assets. They could have or should have disclaimed those assets, such as life insurance. So these kinds of things have to be guarded against. And I will say that our financial advisors and CPAs on the webinar, we need to be aware not to advise clients to immediately retitle assets in contradiction of the estate planning documents of the deceased spouse. This is something that we see a lot of. Inheritance tax does not apply to most beneficiaries, but where it does apply, we want to be cognizant of that. So that's a little place where we could trip up, especially with regard to retirement assets. Sometimes fiduciaries will forget that this niece or nephew who is receiving an IRA, that person is subject to inheritance tax. And now we have helped facilitate the receipt of that IRA, but we forgot to help facilitate the payment of inheritance tax. That is a problem that we want to be able to avoid. Portability election, we now have a massive time, 5 years, to make the election from the date of death of the first spouse to die, but we want to be aware of that. The Q-tip election, we want to be aware of that for people who are establishing a marital trust for the survivor. Failure to make a claim, a notice, to creditors to foreclose the claims of creditors. That's something that we want to make sure we talk about, and we don't have to run notice to creditors in a non-probate administration. But generally speaking, I think it's a good idea to do that. And now you as a fiduciary have done everything you can do to foreclose the claims of creditors, even though generally speaking, we're probably not going to see many claims of creditors against a trust. Completely communicate with the advisory team. Try to develop a plan of action. Who's the quarterback? Who is really coordinating with the client? We want to be collaborative, but not confusing. We want to invest significant time during life if we are an advisory team to support clients and be ready for this event in advance. Where there is an illness involved, where there is someone who's clearly struggling, my experience has unfortunately been that person's time on the earth is generally much more limited than most of us realize. So we need to expedite meetings, be available, be empathetic, and try to get things done before death. Ascertain a person's wishes. Encourage them to use a letter of wishes or a memorandum of intent. If the majority of people used these tools, a letter of wishes, which we're happy to send out to you, this is a thing that augments a will or trust and gives a trustee advice informally from the creator of that document about what their vision is of how that trust should work for the future beneficiary. So these kinds of instructions we should encourage. Advanced organizational tools during life. We talked about this. Educating family members. This is one of the biggest things I think that could be done that is not done today. Elville Associates strives to do this, and our wonderful clients really do make an effort to educate their fiduciaries and family members. I think this is one of the biggest keys to making administration work the way it's supposed to. Again, reporting and a systematic method of communication. We've talked about this. Disseminating information, having an organized process for survivors, and giving clients confidence that their team is actually communicating, that they're competent and they're working together. These are things that can be done prior to the passing of someone. So we've gone now about an hour and 10 minutes or so, and then we're going to wrap up. I'm hoping that discussion really set the stage and gave you a set of parameters to work through. We're here to help you. We're here to collaborate with your team or to help you form a team. So we encourage you to set a consultation with us if you have any concerns or questions. This could be a concern about educating fiduciaries. It could be how to structure fiduciaries. We have other webinars you're certainly welcome to watch. We have high-tech conference rooms. We're here to help you relax and really help you think through these issues with no fear. There's really nothing to fear in the sense that when you do meet with an attorney with this kind of need to get information, even if you do not move forward with any planning or any kind of fiduciary planning, there is no fear about having shared information. So there's an attorney-client relationship. There's nothing for you to be concerned about. We would suggest that you provide as much information as you could prior to a consultation. We want you to make a list of questions. There's been some excellent questions today. If you have questions about current documents, we encourage you to bring those. And if you don't have an advisory team, we want a collaborative team. We want to help you to form one. And if you have one, and you're concerned about some aspect of it, like communication or being able to make sure this thing is actually working the way it should, we're here to help you do that. And as I mentioned earlier, we're here to help you have time to think through these issues in our very busy and uncertain world. And with that, I'm going to turn it back to Jeff. We're here to help you determine what your goals are, whether it's as a fiduciary, as a beneficiary, as a grantor. What are your goals and what are your needs? And we're here to help you. Jeff, I'm going to turn it back to you. It's been a wonderful time together. I thank everyone for taking time on this beautiful day, and I wish you the best rest of the day that you can possibly have.
Thanks, Steve. Great presentation as always, pulling everything together into a concise hour and 20 minutes here with us. So now would be your time to get your final questions into Steve. We have a few more minutes that we have to answer those questions. While we're getting those last questions in, I'll say, as always, I'll be sending out a follow-up message with some information. The video from today, I know some people had to jump off just a little bit early and were asking about the video. So I do send that out. I'll send the materials out again, along with the letter of wishes template that we use and suggest here at the firm. Also, this is probably the question I get asked the most here at the firm. All of our webinars are available on our YouTube channel, and we have dozens of them on our YouTube channel. So I'll be sending out the link to our YouTube channel. It might be a great address to bookmark for easy access. We're adding new ones every week, and might be something good to hold on to for your future reference. As far as our webinar series goes, we do have a little bit of vacation coming up, so we'll be back in full force in July, but we do have an in-person presentation we are really looking forward to on Thursday, and that is at 5 to 7 o'clock at Busboys and Poets over in the western part of Columbia. We're with Andre Lingham, Officer Andre Lingham, formerly of the Howard County Police Department, now the founder and president of the Center for Elder Justice and Education. He's going to be offering, along with Steve, his presentation, Financial Exploitation, Frauds and Scams Targeting Older Adults. So we've offered that here on our webinar series a couple of times, been very popular, and Steve and Andre will be teaming up and offering that presentation live at Busboys and Poets on Thursday, 5 to 7. You do need to register beforehand. Be sure to go to our website. There still is just a little bit of room, but it's going to be a very busy and enjoyable evening. So we hope you can join us. And let's see if we have any final questions for Steve. Doesn't look like we do. Steve, you answered all the questions that anybody could possibly have about estate and trust administration. So well done.
Thank you.
So thanks for your time today, and thanks for being part of the Elville webinar series, and we'll see you again soon.
Thank you, everyone.